And hello, everyone. Today is Tuesday, October 26, 2021. My name is Melissa Andre. I'm the Executive Director of the Tax Review Board and facilitating this Zoom hearing today. Please be aware that this is a public meeting that is being recorded because the meeting is public. Oh, I'm sorry. Yes, because the meeting is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. All right, Nancy, who is our chair, can you please take it away?
Thank you. This is Nancy Cameradiner, chair of the board. We have two items that are on today's agenda that have been continued. The first of those is 240 Roberts Avenue, LLC, last four digits of the docket 9608. And the second one is Unity Loft, LLC, last four digits of the docket 9607. So that brings us to the other case on this agenda. It's BHP Philadelphia LLC, last four digits of the docket 9579. Who is here for BHP?
Good afternoon. My name is attorney Bob Careless from Cozen O'Connor on behalf of BHP. I'm joined by my client, who's Dario.
I'll have them introduce themselves if I may. Please, excuse me, please identify yourself for the record.
I'm Dario Petrangelo with BHP Properties.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you. Who has this matter for the city?
Good afternoon, everyone. My name is Althea Udo-Yang. I'm an attorney with the Philadelphia Water Department.
Okay, and do you have any witnesses who will need to be sworn?
I do have Henry Bernberg. Henry, if you can show your face.
Please identify yourself for the record.
Henry Bernberg. I'm with the Philadelphia Water Department.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. I don't know whether you or your colleague there will have the numbers for the record. Do you have those?
Yes, and I have a brief opening statement. Should I do that all now?
Let's get the numbers on the record and then do the opening statement, please.
Great. So we have a principal of $97,899.02. The penalty is $74.64. The total amount is $97,973.66.
Okay, thank you.
Althea, I'm sorry. Can you tell us the time period for this amount?
Yes, these are stormwater charges from 2010 until today.
Thank you.
Okay, your comments, if you have some before we turn to the petitioner.
Sure, I just wanted to briefly explain. This matter involves stormwater only fees on a stormwater only account. I just provided the numbers. The current property owners, they purchased this property of 67,000 square feet on October 15th of 2020. At the time of their sale, there were liens owed to the city in the amount of $96,801.71. Title companies have reached out to the water department for payoff amounts prior to the sale. However, the balance remains unpaid until today. There have been maybe one payment since the beginning of this account. And not only did the prior owners not pay much on this account, they never challenged their stormwater fees before the Tax Review Board or through the water department's internal stormwater review process. And I would just submit that these current owners do not have stand-in to challenge what the prior owners' bills were.
Okay, let's turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board. And we'll need to address the questions raised by the city at another point in the presentation.
Sure. Well, I will just briefly address the last point that the city made. These liens filed against the property are in rem liens, which means these are liens against the property, not against a prior owner per se. To our knowledge, the city is not pursuing an assumpsit or otherwise what's called an in personam action against the prior owner. And What that means is that these are charges against the property itself, not against a specific owner. So we bought the property subject to these liens. We bought the property with the intent to clean up these liens. Our client wants to, this is a struggling area of the city. We want to improve the city, this area of the city. We, upon purchasing the property, realized that and if I could I just share my screen? You want me just to, Madam Chair, I could just get into the presentation here.
You should
It
be
might
able
just
to.
streamline things. Can everyone see my screen?
Now we do.
Thank you.
Yes.
So just briefly, this appeal follows a decision by the city to reduce the impervious coverage, which previously was shown to be in this area right here that's now not shaded in the purple. It was approximately 66,000 square feet. It's now shown as 23,620 square feet. That is proper. The city's liens going back to as early as 2011 were filing liens based on an improper impervious calculation. Now, the city has rendered a decision dated July 6th, which granted our
Of what
request-
year, excuse me?
I'm sorry, 2021, we filed an appeal
Okay,
asking that the impervious coverage be reduced from the 66,153 thousand square feet to the 23,620 square feet. That was granted. Now, the issue that remains is, and if I could just stop sharing. briefly.
Mr. Careless, I'm just asking, could you at the end sum up the percentage difference that would help me greatly, just when you finish your presentation?
Sure, we can try to go through that. Hold on. Sure. So the city's records now, if you can see my screen, I'm showing you just the website of the city. It now shows the correct impervious. It previously had this entire area as impervious for purposes of calculating the stormwater charges. It has now been updated appropriately following the decision. In fact, it even, if you were to go back in time, it now even shows.
Could you go back to the previous screen? I could do my own math. Once I was writing down the impervious area. I apologize. I just want to
I'm
know.
sorry, with the screen that I was on,
before-
sir, or would you like just to
No,
go
before or after the first screen with this one. Thank you. I'm good now. Thanks.
You're okay? Okay. So, I won't go through every year. I know the board has other matters here, but now, if you go back historically, the monthly stormwater charge is now in line with what is the impervious calculation. And yet I can snip this going back 13. This is the monthly stormwater charge. It varied every year due to the rate. So 14, so for example, this has now been updated. The monthly charge is here. The city is, as council noted, is still showing balances. I think council said $97,000. The time of the purchase was $96,000. What we're asking for is that the city's records be updated accordingly with what the decision was, which you can see here in our decision. The monthly stormwater charges were adjusted. This was going back to 2014. We were asking at least back to 2012 because we can show, these are just historical photographs from the property back to 2012. This is from the city's website. This is a picture scenario from the same website where you can see that the property is in the same condition that it is today in terms of its impervious. And the city, I guess, almost all but agreed with us going back until just July of 2014. So the relief that we're asking for is that whether it's the liens or the city's records, because if I could just go to this next page here, this is just a recent bill, and you can see the standard bill to February of 21 is $819 approximately. where it should be in line with, if I flip this website, can you see the website now that I'm showing?
Can see the bill.
You can see the
Yes.
bill still. Okay, so
bill.
I have to just toggle. It's just, please bear with me for a second. So where it's the standard bill, for example, in 2021 is showing $819, it really should be, you know, more than half of that, right? Less than half of that.
If I could interrupt just a minute to make sure so are you saying, Mr. Careless, that although the city has agreed or adjusted the percentage or the square footage of what's impervious and pervious, that's not being reflected in the billing process?
For the historical parts of the retroactive parts of it. So where the decision here seems to indicate, Ms. Weiss, you know, going back to July of 2014, that the monthly charge should have been $310.24. If I were to go to, you know, this, I'm sorry, I apologize. I just lost my screen. You know, if we were to go to the bill here and go down to, you know, 2014, for example, and this is consistent with every year. What you're seeing, the standard bill, $712.
Can I see it to 2021, like since July, what it looks like? Do you go up that recent?
We go up to February. This is the most
February,
recent.
okay, so you don't have what it looks like since the July decision.
But I could ask my client just to confirm under oath that.
I could ask the city, that's okay.
Yeah, or the city,
Thank
yeah.
you.
So, you know, and if we're wrong about that, if there's been a more recent bill that's been issued that corrects back to the decision back historically, you know, we'll willing to adopt it, we'll accept that. But what I suspect is happening here is that the balances that the city is showing, and I won't speak for council, but is that what they've leaned is this standard bill rate. And that's what's still being shown in the records for the city for purposes of billing. So we're asking that the board, number one, reduce to the correct principal balance, which is in line with the July 6th decision. And that should be, we can figure that out. That's, you know, that's on the city's records here. This is the city's own website. We can go through and figure that out year by year. And then we're also asking for an abatement of penalties. I mean, we're here in good faith. These charges aren't from, you know, these going back. This isn't our client's charge or the apartment owner's charge. We're trying to fix up the property. We want to square this with the city. We just don't feel that the city should be entitled to a lien for almost triple what is actually should have been charged for the impervious. The impervious was, the records were wrong for the impervious calculation. We showed it. We got a decision which agreed with us on that. And we're just asking it to be correct back in time. That's all.
So is the $97,000 and change that's currently owed all based on 66,000 square feet?
Yes,
All of
that's
it.
correct.
So there's
Yeah.
been no adjustment based on the July 6th decision that you're referencing?
To our knowledge, the only adjustment that's
That's
occurred
correct.
has been, you know, here on this website, but you know, I won't speak for council, but our understanding is that the charges have not been updated to be, you know, commiserate with that July 6th decision.
Thank
Yeah,
you.
if you don't mind me jumping in, exactly what you had asked or what you had stated is true. They agreed that it's in the 20,000 range, not the 60,000 range, and they fixed it for today, but nothing going backwards.
Okay.
If that makes sense.
Thank you.
Do any board members have questions before we turn to the city?
Yeah, when did you start talking to the city about this issue?
I'm sorry, could you repeat that? I couldn't hear you.
Yeah, when did you guys start talking to the city about this issue, this square foot issue?
Dario, do you remember when I believe it was promptly after you closed on the property and we were told we had to go through. Now, if I could just provide a little more color here. We did file, we had a previous appeal filed, I believe earlier in this year. We filed it as a water charge, and it was, hopefully this is in the records, but we filed it as a water appeal. these are stormwater charges. Apparently, they're two different forms. So we had to kind of abandon that process, file with the city, with the stormwater at it like an administrative level review, which is what we received here. This was, filed, in the spring, and we got a decision in July. And then what we're asking for, what didn't come clear here is, whether we get the relief retroactively on the bills. So we've been in communication with the city. We've just sort of been in line with, getting this appeal heard.
So it's clear that the city is even admitting back to 2014, you should only been charged for 23,000 and some change impervious square feet instead of the 67, but it hasn't been reflected on the bill.
That's correct.
Okay.
And you're just arguing about the other 2 years to 2012, which is when you can prove the land, right?
We can prove the land going back to
2012.
2012. However, I would add, though, that's just what's available to us publicly through that process. However, sir, if I could just direct you to, if I were to go down to, which is the earliest year, which is 2000, let's go to 2010, 2011. The city's records are now showing what the correct monthly stormwater charge should be, commensurate with the appropriate impervious coverage. So the adjustment's been made going backward as early as 2009 for the city's records.
Okay, thank you.
Okay, thank you.
Any other questions before we turn to the city? I guess not. So let's hear from the city.
Okay, Henry or Mr. Bernberg, how long have you worked for the water department?
6 years.
And what's your title?
I'm a GIS Specialist 3, supervisor of the Stormwater Billing Unit.
Okay, and are you familiar with the property at 3025 North 19th Street?
I am.
And how are you familiar with this property?
I reviewed the appeal after it was submitted, and I also reviewed the stormwater billing team's processing of the appeal.
Okay, so let's talk about the stormwater appeal. When was that submitted?
June 21st, 2021.
Okay. And based on that appeal, were some adjustments made on the account?
Yes, we updated the impervious area and adjusted all of the charges dating back to October 16th, 2020.
Okay, and why did you adjust based on the October 16th, 2020 date?
That was the date on the deed of sale to the current owner.
Okay, and is that also listed in our rates and charges at that time, if you know?
So at the time, the rates and charges stated that stormwater adjustments would be effective going forward. They wouldn't be made retroactive, but we did have an internal policy that the effective date for stormwater charges would be for stormwater adjustments would be based on the date of the deed for the most recent deed, or if there was other evidence supporting, so if it had been like a transfer between, or a deed of correction or something, we would use the last deed of sale.
Okay, I just want to direct you to the water department's rates and charges at the time of this appeal. Can you see the screen?
Yes.
And can you just let us know what the effective date of the rates and charges were?
Looks like October 1st, 2020. So right after, or right before the date of sale.
Okay, so now I would like to direct you down to our adjustment section. Just give me 2 seconds. I think it's section 7. Okay, so this is for stormwater adjustments, I believe. And it's non-residential properties. I just wanted to, if you can just read into the record. God, where did it go? Please bear with me. I just wanted to read in the record the exact language of our regulation at that time on how we applied retroactive credits. Please let me find it. I apologize, I just had it. Please bear with me. Okay, here we are. So this is the adjustment procedure. If I just wanted to direct your attention down to, okay, to section Roman numeral 7. If you can just read what our regulation was at that time.
If the adjustment appeal results in revised GA and/or IA calculation, correction of the property classification, correction of parcel identification, or revisions to the default charge allocation, then the adjusted SWMS charge will be effective from the date of receipt of the adjustment appeals application.
Okay, but instead, we didn't go back to the date of the application. We went back further to the date of the sale. Is that correct?
Yes.
Okay. And if you may, do we know what the state of the property was when the prior owners owned it? I know they're arguing that it was the exact same, but do we know for sure how that there wasn't any changes made in construction or anything like that?
Yeah, I mean, so I can review some historical imagery, and it does look like, the parcel has been in its current condition since the sale.
Okay. And I also wanted to just talk about the stormwater parcel viewer that opposing counsel just brought up. The historical data, or the new rates to go back and were changed up until 2011. Can you just explain why that is?
Yeah, so the way that the parcel viewer works is it displays historical charges based on the current data. It isn't an accurate representation of historic charges or of what charges necessarily should have been at that time. So a good example would be, let's say that a new building was put on this property, and we updated the impervious area. The charge would go up with the higher impervious area. The parcel viewer's historic charges would reflect that new construction, even though that new construction was more recent.
How far back would that go?
It would be reflected in all of the charges on the website going back to 2010, July 1st, 2010, when our program began. This is just a bug with the way that the website works. It's basically impossible for us to maintain a database of the full charges, we could either maintain what the current charges are and use that, provide that as a reference for historical charges, knowing that, they may not reflect what the actual charges were at the time, or we can provide the historical charges and not provide any way to have a record of changes that have been made, but we can't do both with the way that the software is written.
So what you're saying is that any member of the public or the tax review board who would look at your website cannot rely on the data that's available there to be accurate?
So the data will accurately tell you what the current charges are.
Why does it go back to the old charges and make that as if it's current? That makes no sense. That isn't accurate data.
So what it will do, it is not an accurate representation of the billed charges. It is an accurate representation of what the charges would be based on the current conditions on the site.
That information is available to the public, is that not correct?
That is correct.
But that is inaccurate. So okay, thank you.
It depends on the situation. When there are changes made on a parcel, then the historic information is not accurate. That is correct. For parcels that have not had changes made, then it is accurate.
I am ready to go to the back whenever.
All right, I got one more question. So what you're saying is, although the website and the city's data is reflecting that back to 2010, the amount of impervious coverage was, or pervious coverage, 23,000 square feet, you're not, the city's not sure that's accurate? You don't know when or it is accurate?
No, the city's website is only based off of the current billing data. We do have internally, historic data that is not published to the parcel viewer. In part because the updates that we will make to, in this case, the changes that were made to the parcel were dated back to October of 2020, even though those changes were made, in June of 2021. So if we had, let's say, used the snapshot data that we maintain internally, that would only show the changes, going back to 2021. The website is also designed based along fiscal years or rate period changes. It's not based on when individual parcels are updated.
Okay, but you can't definitively say that you are sure, or the city is sure, what the property looked like in 2010, even though the website's reflecting a particular...
I can look at a variety, multiple sources of historic data. Going back to 2010, I can actually show you if I can share my screen.
It was really.
I do have. I do have a record of.
I can tell you that for certain.
I'm sorry. What?
It was the same property in 2010.
Thank you. All right.
Yeah. Well, it was actually. It was actually completely paved over in 2010, according to the historic imagery that I have access to. But I do have a full record of every update that was made to this parcel.
And did it change then?
And when did it change?
Let's see. So, like I said, we updated the parcel in June of 2021.
That was because they submitted an appeal, correct?
Yeah. Yes.
Okay.
Yeah. And our effective date policy at the time was that we do not make adjustments to charges prior to the the current owner's ownership.
But I thought there was testimony earlier that indicated that you had data that showed that the time period going back to about 2010 looked like it does, or like it did at the time the new owner took possession. Am I incorrect about that? Because I thought that's what I heard.
No, we do have, if I review the historic data, the current conditions do look like they date back to around 2012, like this imagery is showing. But our effective date policy is that we do not adjust prior to the ownership, the change in ownership.
So what I hear you say is that the impervious, you're comfortable that the impervious level should have been the 23,628, but the policy of the water department don't allow you to go back that far.
Yes.
Okay.
That's a, yeah.
I have another question in terms of going back. I'm not sure if anyone addressed this directly, and that is whether or not you have verified that the previous owner received bills and did not pay bills for the stormwater in that time period prior to the current ownership. I don't know if you have that or if someone else from the city has information on billing and payment with the prior owner.
I
The
believe,
implication is that the prior owner didn't pay, but I didn't know whether there was anything factual that supported that.
Yes. If you give me 1 second, I'm going to log into Basis right now. And I'm going to share my screen with you all. Hopefully this works. Say share screen. Can everyone see this is the Basis screen, the prior owner, Enki, Indiana?
Yes.
Everyone see that?
Yes.
Okay. So these are all the charges up until February 8th of 2021. All right. So I believe when I was looking at this account, if I go down to 2010, I did see some payments previously.
But the numbers that have been given to us today reflect all of those unpaid amounts.
Correct. It's the amount that was transferred over from this old account to the new account. There was a balance transfer for the amount of.
Okay, I just wanted to get a little track on the history and the relationship to make sure that what was transferred.
Sorry. I did have another exhibit as well that I just wanted to show you because I do believe the prior owners were aware. We've received several calls from title companies asking for a payoff. I can just share that as well. Sorry, that's the wrong one. Excuse me. Oh, that's my desktop. Here we go. I've marked this as City Exhibit 3. This was right before the call or right before the sale. If you look at the highlighted line, this was just the title company requesting payoff. I'm not sure, and I did want to ask if the petitioner had title insurance at that time and why it wasn't taken care of at the sale. But with that, I don't have any other.
I can address that. I mean, we knew about the liens. The intent was to buy the property and work with the city to resolve the liens because we knew the calculation was wrong. So rather than get into an issue about title, we didn't expect that the city would push back like this, where there's obviously a mistake about the impervious calculation going back at least until 2012, that we thought we could just get this squared away to what the city is actually entitled to based on the impervious. So I don't know what relevance the title insurance has to this process. I mean, we're here.
I was just bringing that up because I don't believe the tax review board.
Hold on, please. Just let me finish, and I don't interrupt you. So again, I don't know what the relevance that the title insurance has. We're here. We're the current owners. These are in-rem taxes that we're the owners of the property, so we're subject to these liens. The point is that the city has liens for triple what the impervious. So that's
Bob, if you don't mind me jumping in real quick. One thing, it wasn't a situation where we could walk away. Like Bob had said, it was something that we thought the city was going to work with us. We bought over the past few years a large parcel that abuts this across 19th Street. The property is on 20th Street, and we're in the demo phase of what was there. So as he said before, we're buying in the neighborhood. We like the neighborhood, and we're just trying to clean everything up and see what the future brings for us there. But it wasn't something at the time we were able to kind of walk from, and we figured that the city would see that, they have a good developer, landowner, looking to do the right thing in that area. And we figured it was a no-brainer. We did our research. We went back, we checked the atlas maps. We realized that it was being billed wrongly for over 10 years. And we thought that, they would want to work with us, create jobs, and better the community.
Were there any discussions with the city regarding your assumption before you actually took possession? Do you know of any discussions with the city about that?
No.
I mean, I think when we started to have the conversation, we were told we had to go through the process with this board in order to have
Okay.
adjustments.
Okay. Sometimes there are discussions and developments that take place prior to the actual sale under circumstances when there are issues at stake. Okay. Any other questions from board members for either the city or the petitioner before we step aside?
I just had one final comment that the tax review board, I don't believe is the appropriate venue to challenge liens on properties. And that's all.
I'm ready to step aside, Nancy.
Okay. Thank you for that add comment. We're going to step aside and discuss our decision.
Thank you.
I'm sorry, I just have one question. Is this principal made of liens?
Yes.
How much of it is a lien?
The $74 was a lien. I thought the principal was,
No.
That was
no,
penalty, the 74.
That's penalty.
the penalty, you said the principal was like 90-something thousand, if I remember correctly.
Right,
Correct.
97,
The principal
899.
was a lien.
So this was all accumulated under the prior owner. So when the balance is transferred, the entire principal gets transferred over to the new owner. I can go back and to figure
Right.
out, there were several liens filed on the property. We file it quarterly every 4 years. Every 4 times a year. So there were
So
liens filed on
how
it.
is that a lien? Isn't that an outstanding balance
Principal,
against the
yeah.
account for that particular property?
I'm sorry, I don't understand the question. How is what a lien?
The amounts that are due as principal, because you kept referring to them as liens and as though they were something different from the principal due on the account.
No, I was just trying to point out that if he's challenging the lien on the property, I don't believe the
What
tax
lien
review
on the
board-
property? That's what we're trying to find out. What lien is on the property?
There's liens on the property for the outstanding amounts owed. That goes back to 2010.
And just
Mr. Careless, when you first started to address this after the purchase, who advised you that the tax review board would be an appropriate forum?
we'd have to go back. Dari, do you remember those conversations? Because I could
Since
tell
we're
you.
starting back at the beginning.
Yeah, because I could tell you, again, what happened was we filed to the TRB, it was under the improper water. And we were told at that TRB hearing, which I can get the dates for the board if they need them. We were told we had to refile with the stormwater petitioner that I believe must have gone to Mr. Bernberg at an administrative level review. Mr. Bernberg and his colleagues then reviewed and then issued that decision dated July 6th. And then the form that came with that decision was an appeal to the TRB. So again, what's being challenged is the principal. That's what's being challenged here. The principal should be adjusted commiserate with what we can prove, which is going back at least until 2012, the impervious surface was wrong. Now, that corresponds with the liens being filed inappropriately, that so be it, but the principal needs to be adjusted.
And did you have any conversations with anyone in the law department? I just talked about the water department. Was there any correspondence or discussion
yes.
with the law department?
We have several emails. I believe counsel here is even copied on some of them with Mr. Burrell. And the law department's been fantastic to work with. It's just I believe even counsel, I don't want to speak for counsel because I don't have the emails in front of me, but I believe her colleagues even advised us that we had to go to the board in order to get the relief that we were asking for.
Thank you. I'm ready to go back.
I'm ready to go back too.
Okay.
If everyone would just hold on one moment, I'm just going to put the board in the back room and be patient while we deliberate. Nancy, are you here?
Oh, I see her.
I see her, but I don't hear her. I don't know what's going on. She says she lost us completely. I'm sorry, this is Melissa Andre. I'm coming back on. I believe we're still being recorded. Nancy Cameradiner has had some technical issues. She was here, but she's no longer here. She just texted me and said that she's lost us completely. Paula will fill in as chair, and Paula, if you can read the decision of the board, please.
Of course. Thank you, everyone. We're coming back into session. The board has had a full discussion of the information and evidence provided by the petitioner and the city, and it is our decision to direct that the city recalculate the bill back to January 2010 based on 23,628 square feet of impervious property and abate the penalty. Petitioner will get a letter. Is petitioner here?
Ryan Boyer, I concur.
Thank you, George.
George Matthews, I concur.
Petitioner will receive a letter with that decision within 2 weeks. Either party may appeal to the Court of Common Pleas should they so desire. An adjusted bill will follow from the Water Department. I'm not sure how long that takes, but Mr. Berber perhaps can fill that in, but you will get an adjusted bill based on the Tax Review Board decision.
Thank you. very much.
Also,
Can
does the board direct that the payment arrangements must be made in a certain amount of time? 30
Within
days?
30 days of the adjusted bill, payment
Okay.
arrangements to be made.
Payment arrangements within 30 days of the adjusted bill being received.
Yes.
Can I just add a note to the effective date that you provided? The data that I have access to shows that, the earliest date that I can show that the paved area was removed is actually the spring of 2012. It was still fully pervious between July 1st, 2010 and spring of 2012.
Which is not evidence that was provided to us during the hearing.
We made our decision.
I did state that during the questioning.
I concur. George concurs. Let's go. We made our
Okay,
decision.
that's our decision. Thank you.
We made the decision, sir.
Okay. Any other questions? I believe that ends this hearing then. So thank you, Mr. Careless, for your information. And thank you, Ms. Udo Inyang. I think that is all the business for the board today, correct, Ms. Andre?
That is correct.
Thank you.
Everyone. This hearing
Have a
is
good
now
day.
adjourned.
Thank
Have a
you,
good one,
everyone.
everyone. Bye-bye.
See you all next time. Bye.